2 weeks time was given to you to file. In fact, nothing is to be noted here.
True.
I've heard the parties.
For filing of
It is
the
just-
written submission.
Yeah. It's just to allow you to file the written.
Written
That
submission.
could have been done. We'll do away with the written argument. Suppose this matter for reserve them.
We'll be filing in within a week.
The private respondent is also there, Lordship. The main contesting respondent.
Just unnecessarily delaying the matter.
On my part, the state respondent, Lordship, I'll stick to my stand in the writ petition.
You have not made any submission, except for the private respondent.
respondent and the review petition.
And as far as you are concerned, you have just canvassed a 1 point issue. Nothing elaborate about that. You have cited your judgment.
True, Lordship.
I will.
Short day next week. Maybe short day.
1 week.
I'll
We'll file it within 1 week, my lord.
Today is 24.
we'll do it by Monday.
Monday.
Sure, Lord.
Made by the counsel for the petitioner. This is matter on Monday.
Monday. Obliged.
Highly obliged, Lord.
Please, Your Lordship. Lordship, I beg to mention item number 1, Your Lordship.
Number 1,
Yes, Your Lordship. Admission hearing. Lordship, my senior counsel is indisposed.
let the matter be called up. There's no mentioning as far as the other parts are concerned. Let the matter be called up.
May I please, Lordship? I beg to mention item number 2. Lordship, may this matter come up after 1 week.
Why?
May this matter come up after 1 week.
You are for?
Respondent number 678.
Who's for the petitioner?
For the petitioner, Your Lordship.
I think this court has made it clear that no further adjournment to be given. You're for the petitioner?
Yes, Your Lordship.
We'll hear you, then you can respond. Otherwise, if we go on like this, nothing will happen. We'll just keep on going on with adjournments and adjournments and adjournments. You start and we'll see.
Matter may be taken up at the end of the board, Your Lordship.
Yes, of course, it'll be called up. It may be taken at the end of the board or otherwise. You be there and we'll see. Yes. Yes.
May it please, Your Lordship. My lord, I beg to make a mention of item number 7, hearing list, Your Lordship. As the arguing and conducting counsel is out of station on sanctioned leave, my lord.
This matter was part heard, isn't it?
That matter, Your Lordship.
Have you finished your part?
Yes, Your Lordship.
You have to respond.
To respond, my lord. Kindly list the matter after 2 weeks, Your Lordship.
Not pre-made by the respondent seeking respondent number
Number 1, my lord.
1 seeking accommodation on grounds of personal difficulty of the direct conducting counsel. Same not be objected to by Alan. Matters adjourned. List the matter after 2 weeks.
Obliged, Your Lordship.
Supplementary list, item number 1.
A modification of the bail conditions, sir.
Acha. Private party, isn't it?
No, sir. It's an NTPC matter.
Okay.
May I please, Your Lordship? Your Lordship, I am appearing as a LAC in this matter, Your Lordship. Your Lordship, I have filed this application for modification of the bail condition, Your Lordship. The bail order was given by this Honorable Court on 16th to 2024, Your Lordship. Your Lordship, the limited prayer in this petition is that I want modification, Your Lordship, of one of the bail condition that they shall not leave the jurisdiction of this honorable court. Your Lordship, the petitioner herein, she wants to undergo de-addiction treatment, Your Lordship. As such, I'm praying before this honorable court to kindly modify this order to the extent to allow me to travel outside Meghalaya so that I can take de-addiction medication, Your Lordship.
What is the stage of the case?
The stage of the case is as evidence. Out of 9 prosecution witnesses, 2 has been examined, Your Lordship.
Yes, Mr. Khan.
I'll leave it to the court, Your Lordship.
Heard Miss the legal aid counsel who has submitted that this application has been filed with a prayer for modification of one of the bail condition set up in
Page number 7, Your Lordship.
BA
2.
but there are
Your Lordship, I'm appearing only for BA 2 of 2024.
BA 2 of 2024 wherein the petitioner therein was allowed to go on bail by this court by the order dated 16/2/2024. The bail conditions, the bail condition in question
Page 14, Your Lordship.
reads as follows. Item to two more. Next, the Land Council has submitted that the petitioner is desirous of getting adequate treatment and rehabilitation in a center which is situated outside the state of Meghalaya. As such, the said condition being an impediment for such a decision, it is prayed that the same may be suitably modified. Mr. K. Khan, Leonard PP, has no objection to the prayer made. This court, on consideration of the submission made and on perusal of the materials on record, including the said order in question, and also being convinced of the intention of the petitioner to get herself to go for the said treatment, therefore the prayer made herein is allowed. Accordingly, in exercise of the inherent powers of this court, that is section 528.
528 is the inherent power, Your Lordship, and modification is 483 1B, Your Lordship.
Under section 483 under bracket 1 under bracket B small b, read with section 528 of the BNSS, the condition in question is now modified to say that to read as follows: that they shall not leave the jurisdiction of India without prior permission of the court. Accordingly, the said condition under bracket 2, set condition 2 more, so supra is hereby modified. Next, needless to say, the petitioner is directed to appear before the court as and when required, be it by a virtual hearing or otherwise. Petition disposed of.
Deeply obliged, Your Lordship.
Daily list item number 1.
Lordship, I pray this matter be listed after 2 weeks, Lordship. Conducting counsel is indisposed, Lordship.
Who's appearing for it?
TT
Yes, miss, you are there.
Conducting counsel is on his legs, my lord.
Any objection?
No.
Mr. Learned Counsel appearing for the petitioner has sought for some more time for this matter to be heard on the ground that the Learned Senior Counsel, Mr. T.T. Ringo, is indisposed on grounds of personal difficulty. On premium, the same not be objected to by the respondent. On premium, the same not being objected to by the respondent. Matter is adjourned. List the same after 2 weeks.
Highly obliged.
Item number 2.
May I please, Your Lordship, let this matter come up at the end of the court, Your Lordship. Senior counsel is on legs.
End of the
Item number 3.
Yes, Mr.
May I please, Your Lordship, this matter we are not prepared, Your Lordship. I'm seeking for some time, Your Lordship.
2020 matter. What is this matter about?
Lord, this matter has a checkered history. There was a dispute, my lord, with effect from 1998 onwards regarding the management of the school. However, the case before your lordship is only with respect to, my lord, suspension, indefinite suspension, my lord, without any conduct of inquiry, my lord, disciplinary proceedings. So that is the only issue, but there's a history to it, my lord.
When were you suspended?
My lord, 2014, my lord. 2014 until date there's no DP, my lord, against, and this is an aided school, my lord.
So when you're when a teacher,
Yes.
it's a teacher, I believe.
Yes, my lord.
Okay. When a teacher is suspended,
Yes, my lord.
as far as the aided schools are concerned,
Yes, my lord.
the procedure of DP is followed according to the rules
Yes.
set out by the government.
Yes, my lord. Lord, I have, in fact, this matter was heard at length previously, and this is the same questions which your lordship had put forward.
You're asking me as if I can remember.
No, I'm just informing your lordships. So, my lord, I have brought the rules, my lord, which govern the teachers of aided education institutions, my lord.
Who's appearing?
Lord, Mr. Sangreso is for the private respondents.
Why is DP not conducted? See, when a person is put under suspension, DP should follow rightly, wrongly, yeah, this way, that way, it has to be, concluded. You're aggrieved only with the, as far as the proceedings is concerned.
Yes, my lord. Suspension and without payment of subsistence allowance. Previously, there was a writ, my lord, in 2012 for salary, my lord. There was a direction in that proceedings, my lord, to conduct inquiry. Inquiry was conducted. Then a finding came out. They suspended me. However, from then till now, there is no inquiry, my lord. Disciplinary inquiry, my lord.
Yes, what do we do? Mr. Shula is also not here, and Mr. Sangresu is not here.
May I have it next week, my lord? Or any date convenient to your lordships.
On pre-made by the respondent number 6, seeking accommodation. The same not be objected to by petitioner. Release this matter after 1 week.
Deeply.
Item number 4.
My lord, connected matter, my lord. 2 teachers. Deeply.
Item number 5.
May please your lordship. My lord, in this, the petitioner number 4 and petitioner number 9, my lord, may I be allowed to strike off these 2 petitioners, my lord? The pleadings need not be amended because it's a common pleadings, my lord. And these 2 have already secured jobs in the office of the deputy commissioners, my lord, in the respective districts, my lord. So these 2 are not interested anymore to pursue. And for the others, my lord, I just got last night some fresh instructions, my lord, because the allegation here was a biasness in conduct of the arbitrary conduct of the selection, and also changing the rules of the game in order to facilitate that. And now I have been informed that they have got some very solid evidences to substantiate. So may I be allowed to bring by way of an additional affidavit? If required, I'll file a proper applications, my lord. But for now, my lord, 4 and 9 may be allowed to be strike off, my lord.
You have to file an application in that regard, or
my lord,
or
because
submission will be,
because here, my lord, only my lord's order directions may suffice, because the pleadings, I'm not going to change any of the pleadings, my lord.
yes, the POB, learned counsel for the petitioners, has submitted that in this petition
9 or 4.
there are
4.
there are how many altogether? There are altogether
Altogether, my lord,
12 petitioners.
yes, it's a group. There are around 12 petitioners, my lord.
There are
12 petitioners.
12 petitioners. However, at this juncture, the learned counsel would submit that the petitioner number
4.
name
Aksha D. Shira.
and petitioner number
9. Tom English Marak.
have chosen to withdraw from these proceedings. It is prayed that their names may be struck off the arrays of parties. The learned counsel has further submitted that there is no, the pleadings are not necessary to be modified or changed, since the same would hold good as far as the case of the remaining petitioners are concerned. Ms. Arkuni Laratji appears for the state respondent and has no objection to the prayer made. Accordingly, as prayed for, the names of said above mentioned petitioners are hereby struck off. The same to be indicated in the cause title of the petition. The learned counsel of the petition has further submitted that this matter may be taken up
2 weeks from now, my lord.
after 2 weeks. Pray allow, list the same accordingly.
My lord. Obliged.
Item number 6.
Your Lordship, in this matter, I'm praying that praying for some time to file a paper book, Your Lordship, because most of the evidence which are annexed in the petition, Your Lordship, it's not fully complete. Your Lordship.
But after 2 years, 3 years, you've come. You should have done that in the first instance. Yes, Mr. Sengupta.
My lord, what I was submitting is that they have filed a revision petition against the sentence of 5 years, my lord. Instead of preferring an appeal, they have filed the revision.
Your Lordship, on
We are
that
stating
regard,
that if they want to go to the evidence, my lord, it is not the right procedure, my lord. They should file by way of appeal, my lord. So, question of bringing on record the evidence is not, paper book will not be required, my lord.
But records must have been called for.
Your Lordship, records were not called, Your Lordship.
Not called.
Not called, Your Lordship.
But this is a disposed of matter.
This is a disposed of matter, but they have preferred a revision.
Your Lordship,
Conviction of how many years?
5
5
years.
years, Your Lordship.
How many years gone?
4, Your Lordship.
2
4,
years.
running 4, Your Lordship.
You wait for a while. Eventually, the 5 years periods will elapse.
Your Lordship, on that regard of revision and appeal, on that regard, this court has heard, Your Lordship. That's why this matter is admitted as revision. It was heard at the initial stage of filing.
No, my lord, that case is not yet decided, my lord. The question of maintainability is still left open, my lord. And we are objecting on the very maintainability of this case, my lord, the filing of revision.
No order has been passed as regard
No, my lord.
maintainability.
No, my lord.
Then we will hear the parties on maintainability.
Yes, my lord. If that is thereafter, if lordship finds that evidence will be required, then they will have to prepare paper book.
This is from which court?
POCSO matter.
POCSO.
Yes, my lord.
So, you see, under the POCSO Act or under the relevant provision of the POCSO Act or even IPC for that matter, any sentence which is below 7 years or 10 years,
Below 7 years is before the single.
it's
above 7 years,
revisable or appealable.
it's appealable.
Anyway, this court will hear, but we might as well, get it over and done with. Now we're just stuck here. It's neither moving forward nor, or backward.
Your Lordship, in that regard, I'm praying that the matter may be heard next week, Your Lordship, on maintainability.
And you prepare.
Your Lordship.
I will not hear your senior on this.
Your Lordship.
You prepare. Mr. Counsel for the petitioner has, for the review, for the petitioner has submitted that petitioner may be allowed to file a paper book before this matter proceeds for final hearing. However, Mr. S. Sengupta, learned additional PP, has objected to the same on the ground that the issue of maintainability of this revision petition has to be decided, and according to him, paper book is required to be prepared only when the matter is under appeal. Be that as it may, on preliminary parties, the issue of maintainability of this petition will be heard at the first instance. As prayed for, this is matter up to 1 week.
1 week.
1 week.
Highly obliged.
Item number 9.
Very good, sir.
Melody, I'm appearing for the state.
Yes.
On the last occasion, the respondent counsel had appeared on behalf of the respondent and sought time to file wakalatnama, and therefore it was the state today.
What is the last order?
Melody, the counsel appearing on behalf of the accused was granted time to file the file.
He is not here.
He's not here.
Oh, here.
But last time I appeared, there was instruction, but I have not received any wakalatnama instruction also, so I cannot appear, my lord. There was instruction, but now there is no instruction, no wakalatnama.
These are the ways the accused is resorting to delay the proceedings. He agrees.
Because I have no instruction, that's why I cannot also comment on that, my lord.
So in the first, what we do is, pending disposal of this petition, we'll issue a non-bailable warrant of arrest.
It is discretion of the court, your lordship.
You're willing to fry your client?
Yes, I think that's why, my lord, there is no instruction to me also. I do not know.
What is this affidavit?
No, that is a affidavit of service, my lord. We have effective service, so we have filed by way of affidavit to bring on record.
Effective service on whom?
On the respondent, my lord.
But he's already.
I entered appearance on the last day.
Just to be on record, my lord.
Mr. S. Pandit, learned counsel, has submitted that though he was verbally instructed to appear on behalf of the respondent herein, however, till date, the specific powers have not been issued upon him. That is, the filing of the wakalatnama has not yet been completed. As such, the counsel could not effectively represent the respondent herein. Mr. J. N. Ranja, Leonard J. has appearing for this state petitioner, along with Ms. S. An, has submitted that the affidavit of service, as far as the notice issued upon the respondent is concerned, has been filed to indicate that the respondent has received the notice in question. The said affidavit is accordingly brought on record. Since the respondent is aware of this matter before this court, it is incumbent upon him to either appear personally or to engage a counsel of his choice, or even to be accorded legal aid if he so desires, and if he is entitled to. However, since no representation is made on his behalf today, this court would adjourn its proceedings for the day. It is to be the next one. It is to be mentioned that if no representation is made on the next date fix, necessary orders shall follow, even to the extent of issuance of a warrant of arrest. As Supreme Court list this matter after 2 weeks.
Published.
Second call, item number 2.
Your Lordship is still on legs, Your Lordship. I pray may the latest matter come up on Monday, Your Lordship.
On pre-made by Ms. Counsel for the Petitioner, place this matter on Monday.